then I started talking about who can you enforce these rights against, right? And the first question that I brought up is, can you enforce these rights against the states? And so there's sort of a bit of a review of what I said last time with a little more detail that I'll go over now. And it's sort of the first two attempts that were made to apply the Bill of Rights. And I put up there a little plus, because, you know, there might be things that are not in the Bill of Rights, but that are nevertheless considered fundamental rights. And we'll talk more about that throughout the semester. Applying that Bill of Rights to the states. So the first attempt was to apply it directly, right? Just say, well, those 8 amendments, primarily, the first 8, apply, establish certain prohibitions against the states. And that theory was rejected in Barron, right, which I mentioned last time, Chief Justice Marshall, 1833. He basically says, right, the U.S. Constitution is about the U.S. government. It's not about the state governments unless it specifically says something about it. States have their own constitutions. You know, if you want a remedy against the state, go look at your state law. Now, the important thing to remember about this case, of course, is this is before the Civil War and the Civil War amendments. So the Constitution that Marshall was reading didn't have this 14th, 13th, and 15th amendments, particularly the 14th, saying no state shall, blah, 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 or states shall guarantee equal protection, etc. So it doesn't seem like a crazy opinion, right? It seems like a relatively reasonable thing to say before the 14th Amendment. Now, life goes on, Civil War, right? 14th Amendment is approved, and after that, the first attempt in 1873, so a few years after the approval and ratification of the 14th Amendment, is the slaughterhouse cases, which we talked about. And the first avenue of attack was privileges and immunities clause, right? 14th Amendment says that that U.S. citizens shall be entitled to their privileges and immunities. Court again rejects the idea that those privileges and immunities include the Bill of Rights. So, in that process, in the opinion, the court says a couple of important things. One of the things it says is that these Civil War amendments are really about slavery. Right? It starts talking about, well, what's the intent of these amendments? Well, the intent was pretty clear, right? We just fought a war over slavery, yada yada, and really that's what they're concentrated about. This is not about, guaranteeing the rights of everybody. It's just about making sure that slavery is outlawed. What does that mean in more specific terms? Well, they say, well, in terms of the 13th Amendment, yeah, that one does apply to the states. It makes a pretty categorical prohibition of slavery. And I'll talk, hopefully at the end of today, about how that works into prohibition against private parties too. Right? So it's a complete, categorical, absolute prohibition of slavery. So it does apply to the states. But it's limited to the issue of slavery only. Right? It's not about discrimination, for example. And it's just slavery. That is later overruled by the court, but 100 years later. 100 years later, the court says, yes, this includes prohibitions of discrimination and what the court calls badges of slavery, but we'll talk about that later on. However, with respect to the 14th Amendment, they say the Privileges and Immunities Clause only refers to the privileges and immunities of the U.S. citizens, and those do not include the Bill of Rights, right? That's what I mentioned last time. They only protect what the court called federally created rights. Now, a better way of understanding this really is to look at the dissent by Justice Harlan. because in the dissent, Justice Harlan says, well, that's kind of pointless, right? If you are just saying that this first clause of the 14th Amendment, which you would think is pretty important, right? They put it there for a reason. If its only purpose is to protect, you know, statutory rights that Congress has created by federal law, well, we didn't need the 14th Amendment for that because we have the Supremacy Clause, right? If Congress has the power to create the right to, I don't know, have balloons on your birthday, that is federal law and it's supreme, and you don't need any, you know, other pronouncements in the 14th Amendment about privileges and immunity. So to say that the only thing that's included in this privileges and immunities clause is federally created rights is to make that privileges and immunities clause completely superfluous. You guys get that? Questions? Everybody understand Justice Harlan's argument here? The Supremacy Clause should take care of federally created rights. Nevertheless, that's what the court held, right? And so, to a great extent, the slaughterhouse cases sort of leaves this privileges and immunities clause completely void. Right? It leaves it without a significant substantive content. Because any content that they leave there should already have existed through supremacy. The other thing that they do is they mention, and I'll mention this in passing too, they analyze due process and equal protection. Again, start picking up on my abbreviations, right? DP is going to be due process, EP is equal protection, B of R, Bill of Rights, BNI, privileges and immunities. And they say, well, what the state did here doesn't violate due process or equal protection either, because again, the purpose of these amendments was to deal with race. And the issue here isn't race. In the slaughterhouse cases, it was a monopoly granted to someone. It had nothing to do with the race of the someone who was granted the monopoly, or the someone that was trying to compete. And so they say, this is only about race. It's not applicable at all in this context. Now again, that was later overruled, but we'll get to that later on. We'll get to that pretty soon, actually. So slaughterhouse stands for this sort of complete rejection of the application of the Bill of Rights to the states, be it through the Privileges and Immunities Clause of the 14th Amendment, the 13th Amendment, or the Due Process and Equal Protection Clause of the 14th Amendment. Questions, comments so far? Now, this holding has been criticized, particularly the Privileges and Immunities part, by scholars, by justices. You have seen in McDonald, even Justice Thomas criticizing it, right? Saying this makes no sense, this has led us to this crazy incorporation thing through due process, which makes no sense, we should have just done this through privileges and immunities. And so on both sides of the aisle, so to speak, there has been criticism of slaughterhouse. Nevertheless, it stands as good law, at least this part about privileges and immunities, and for the most part, the Privileges and Immunities Clause has remained sort of pointless. There is one or two exceptions, and I'll mention one case in particular as a bit of a footnote. There's this case, Sands v. Rowe, which is relatively recent. I don't have the year, but it's 90s or early 1000s. so less than 20 years ago, in which it had to do with California limiting the rights of welfare recipients. Specifically, it would limit the amount of welfare that, or condition, or the receiving of welfare benefits for those who had just moved to the state. Now, this is interesting to me in particular because I studied in a California university, and I couldn't pay in-state tuition the first year. Right? When you move there, you have to pay out-of-state tuition once you've lived there for a year, and you could prove it. They actually made you, I don't know if it's still this way, but they actually made you go every week to sign a roster saying, out here. So you couldn't leave for a summer job, for example. And it was something similar here, but with welfare, right? For that first year, you were limited in the amount of welfare until you establish your residence in California. And the court says this is unconstitutional under the Privileges and Immunities Clause of the 14th Amendment. So there's that, right? I mean, it's kind of a very specific, out of the blue kind of thing that the court did recently. Does this mean that the court is in the next year is going to expand privileges and immunity? Who knows, right? But they used the clause for that particular purpose. Now, why do you think the court did that in that case? Thinking back, right, to the logic of Slaughterhouse, without overruling Slaughterhouse, they find some content here. And theories.
Could it have something to do with the socioeconomic trends of maybe the kinds of people who would be excluded from the welfare program upon receiving that?
What do you mean? Go more specific.
This is controversial, but there are racial trends to socioeconomic conditions, and I don't know if it applies to California. I've only been in the South, but could that, since they say it only deals with race, could that be the way they tied it into the welfare program?
That's a good theory, right? There's an underlying sort of racial reality here. The people who tend to move from state to state and end up on welfare might come from a particular racial group more than others. So could it have to do with race? It might. In the justices' minds, that's not what they argue.
Okay.
But it's a great theory, right? And it would be consistent, I agree, with this logic about this being about race, right? The 14th Amendment being about race.
Right. The other thing I could think of was that the slaughterhouse cases involved the right to make a livelihood, right? And that also ties into welfare, but slaughterhouse cases rejected that as a proper justification for privileges and immunities, so that's why the most, obvious logical connection to me wouldn't apply.
Right, and also people tend to move in search of jobs, right?
Yeah.
There's a connection there between moving from state to state and jobs. Again, yeah, but they couldn't use that because it was, contrary to slaughterhouse. So great analysis there of both things. Now, what rights, when the court in slaughterhouse talks about these federally created rights, they mention a couple of things. What do they mention? Remember? Who else? It's Woodward. Look at the opinion. What do they talk about there? I'll give you one. They talk about navigation. Pretty random thing. Right? The right to navigate in the navigable waters of the U.S. Remember, they're talking about the rights of the U.S. citizen. Right? What rights does a U.S. citizen, because you're a U.S. citizen, have? They talk about things like travel to foreign countries, and they don't say it this way, but it's almost like you have the right to go to the U.S. embassy, you know, if you get caught in France somewhere. Mr. Slackman.
The right to peaceably assemble and petition for redress of grievances.
Right, they talk about writ of habeas corpus, redress of grievances. They talk about going to Congress, sort of like, you know, engaging your federal government. And there's another thing that's sort of underlying that with navigation and sort of being in foreign countries, and it's the right to travel. Right? The right to move about the country. And that is what the court talks about in Sands v. Roe. And we'll talk about the right to travel a little bit more later on. But that's what they concentrate on. They say, as a U.S. citizen, right, as a national citizen, you have the right to move around the country wherever you want. And by limiting your receipt of, in this case, welfare, but really any kind of government benefit or right or license or whatever, right, they are limiting your freedom to move about the country. You know, you can think of, it would be interesting, I think, Ms. Masagi, if they had said, if California had said something like, you can't take a job in California until a year after you've been here. You know, they would probably have then said, well, yeah, what we talked about here in Slaughterhouse about, you know, profession and whatnot doesn't apply in this case, because now they're limiting your ability to move. Of course, I don't think any state would be crazy enough to do that. You know, who knows? It might happen. So that's, you know, that's there. It has a lot to do with this right to travel idea, which we'll talk about more later. But you should be aware that there is some there, as was said about it. So any other questions about Slaughterhouse or privileges and immunities? Remember, don't confuse, and I know we didn't go over the Article 4 privileges and immunities, but just be aware that there are two different things. And if you have questions about Article 4 privileges and immunity, you are more than welcome to come talk to me about it or bring them up in review session, even though it's not going to be on the exam, but it could be in the bar. So, you know, at any time between today and the bar, feel free to come to me talk about Article 4. Or anything else, really. Yeah.
The Supreme Court also says that welfare is a property right and that you have due process rights to it. So if they've granted someone welfare awards and then they limit it because you just moved here, is that unconstitutional under a property right kind of thing for the U.S. citizens to have that property right?
You could have a due process argument too, yeah. You could even talk about maybe equal protection. We'll see why the equal protection one wouldn't really fly unless you could establish some kind of racial thing, right? Which is not that far-fetched. I mean, we're talking about California. They have a lot of Latino population. They might not want more, right? I mean, you could make some equal protection argument. We'll talk about that later. We'll talk about the due process issue too. Yes, I mean, you could make that argument. To be honest, I don't remember why that wasn't the argument made in this particular case, but you know, litigation and strategies and those things. You know, the way that the cases are positioned when they come to the Supreme Court, that was the only issue before the court. But yeah, you could have made due process right. Now, to talk a little bit more about due process. Make sure I'm not skipping it. So the third approach. I mean, we sort of know that the Bill of Rights applies against the state, so how did it happen, right? So you have approach number 3. Well, even though, right, the due process argument had lost in Slaughterhouse, people kept making it. Right? They came back to the court and they said, well, you know, some of these rights are so sort of fundamental, so basic in our conception of justice, that you should recognize that some of these rights are sort of inherent to the idea of a process of law. They are so basic that they must be part of that due process, whatever that due process might be. And so the court, in a series of cases, beginning with a case called Twining, begins developing this thing that I'm going to call the fundamental, and that your casebook calls, I believe, the fundamental fairness approach. And what they do is they say, okay, there are certain things. In Twining, the language they use is that are fundamental principles of liberty and justice, and that therefore must be considered to be part of that due process that the 14th Amendment guarantees. So in Twining, which is 1908, they talk about fundamental principle of liberty and justice. Fantastic, and that sounds really pretty, right? But what the heck does it mean specifically? Well, what the court does is it does it one step at a time, right? On a case-by-case basis. In Twining, what they were actually talking about was the Fifth Amendment privilege against self-incrimination. And the court actually holds that that privilege is not fundamental enough to be incorporated in the process, which might, at least to me, seems a little shocking. Right? I mean, the right to not testify against yourself, we sort of think of as one of the basic, most American rights we can have, right? Nobody can torture you into confessing a crime. It's like Inquisition level, right? Well, the court in 1908 was still not ready to declare that a fundamental right. So, Fifth Amendment privilege. That's why I'm putting this in blue, because it starts opening the door to this idea that the due process clause might include some fundamental rights, but it says the Fifth Amendment privilege is not fundamental enough. Of course, that gets overruled later, so you can imagine. Second case that I'll mention, Gidlow. This is a free speech case. And it's 1925. In this case, however, the court does say free speech is fundamental enough. Now, what has changed? Well, the particular right has changed, right? We've gone from Fifth Amendment privilege to First Amendment free speech. Both textual rights in the Bill of Rights. So this is not about text or not text. and 17 years have gone by. This one is bugged out. This is brand new, I want you to know. And the blue one didn't even work. Ah, man. Then, there's Palco. This is 1933, I think, 37. Look at how the years are going by. And in Palco, the language that the court uses is there are rights that are the very essence of a scheme of ordered liberty. There's this idea of ordered liberty. Again, really pretty words without very much specific meaning. They talk about these rights are rooted in tradition and conscience. Now in Palco, you were dealing with double jeopardy. Everybody know what double jeopardy is? Can't be tried twice for the same offense, right? Double jeopardy. Again, textual right included in the Bill of Rights. Shall not be twice put in jeopardy of life, limb, or property, or whatever the hell it says. Not fundamental enough. 1937, right? We've already turned the corner on Lochner. Great Depression has already sort of had its worst moment. We're still denying people double jeopardy. And again, all of these cases, of course, don't establish the general rule. So they say there are some rights that are so fundamental, that are fundamental principles of liberty and justice, that are, you know, of the essence of ordered liberty, that are rooted in tradition and conscience. But there's no general rule. We're gonna, it's not like they say, you know, if they're on the Bill of Rights, then that's good enough. Or they say, if they were in the Magna Carta or something, that's good enough. No, they're doing it on a one-by-one basis. And the last case I'm going to put up here is Adamson. And this one is 1947. But there's an important character in the court at this point. Justice Frankfurt, who will have a pretty transcendental participation in this debate. Okay? And Justice Frankfurter in this case talks about the ideas of decency and fairness. Adamson, again, had to do with the Fifth Amendment privilege. So it, in a way, is reconsidering the holding before. And now they do this really weird thing in which they say, you can't compel somebody's testimony, but you can comment about his silence. Right? So the prosecutor can't sit you down on the chair and make you testify. But if you refuse to testify, he can tell the jury, oh, and by the way, he didn't want to testify. Right? That should tell you something about, you know, if he didn't have anything to hide, right? Which is almost as damaging to a defendant. So, again, this was later overruled. So that's how things stand in the 40s. Questions so far? That's the first step at incorporating due process via this fundamental fairness approach. Mostly ineffective, but things start creeping in, right? So the First Amendment creeps in Gitmo. The part of the Fifth Amendment privilege creeps in Adamson. Now after this, you can imagine the court's composition is changing dramatically, right? This is when, after the 37, FDR starts appointing a whole bunch of justices, yada yada, and the Warren Court sort of starts to take its shape in terms of its composition. In the 40s, later than the 40s, Eisenhower appoints Warren in the 50s. And then the debate takes a turn and becomes this debate between Justice Frankfurter on the one hand and Justice Black on the other hand. Justice Frankfurter, well, let me start with Justice Black. Justice Black goes back and says, we should have a more definitive rule about this, right? This idea of not having a general rule and doing it haphazardly is really problematic. It tends to, have judges just do whatever the hell they want, right? Unelected judges. And so he proposes this idea of total incorporation. You will later see when we do the First Amendment, Justice Black, Hugo Black, was a huge defender of First Amendment speech rights. He was very dramatic. He said, if it's speech, the government can't touch it, period. And his rules regarding speech were very, very protective of speech. On the other hand, he says, but this whole thing about expressive conduct, things that look like speech but aren't speech, no, those are not speech. So those don't get any protection. So he was a very black and white kind of guy, right? Same kind of idea here with the Bill of Rights. Let's just incorporate everything. Everything that's in the Bill of Rights is incorporated through due process, and that's it. And we're done. Right? Simple. And then you have Justice Frankfurter. Let me see if this one works better. With what has become known, the theory of selective incorporation. Oh wait, this term incorporation, it sounds more fancy than it is. It just means you incorporate the rights that are opposable against the federal government through the due process clause of the 14th Amendment so that you can oppose them against the state. The theory of selective incorporation is just that. It just says we are going to selectively incorporate some of the rights included in the Bill of Rights. Now, you're going to tell me, well, that's the same thing as the fundamental fairness approach, right? What's the big deal? What's the difference? Well, there's a very important difference. The difference is that on the fundamental fairness, you could sort of reshape the rights. And so the Fifth Amendment privilege right, for example, you could say, well, using the cannot compel part of it against the states, but we're not using the cannot comment on the silence part of it. You could apply a different Fifth Amendment privilege to the states than you do to the federal government. See what I'm saying? The right to free speech could be different under the 14th Amendment versus under the First Amendment. That was the fundamental fairness approach. Under selective incorporation, that's not the way it works. Under selective incorporation, if you incorporate free speech, you incorporate the whole thing. And so every case that the court decides regarding the First Amendment and how it applies against the federal government will be binding against the states. It's all the same. So in that sense, it's simpler. It eliminates some of the confusion and some of the, subjective interpretation of the rights. So, incorporate only some rights but it incorporates the whole right. That make sense? No? I see shakings of heads.
It incorporates only some of the rights, but it incorporates the whole rights.
No, the whole right.
Okay.
Every single one. So there's free speech and there's freedom of religion. You can say through selective incorporation, I'm going to incorporate speech but not religion. But once you incorporated speech, you're incorporating speech completely, as it has been defined against the federal government. You can't incorporate, part of the speech right. You can't incorporate the prohibition of content-based restrictions, but not time, place, manner. No, you bring the whole jurisprudence of it with it. Hold on. Yeah.
The total incorporation, that's where everything just goes to the 14th. So it's
Everything,
like,
the whole
okay.
thing, and the whole Bill of Rights with all of its jurisprudence. And this, right? So the Justice Black's approach is really simple. You just bring everything in. Justice Frankfurter's is it's somewhere in between. Right? We're going to bring some of the rights in, but once you brought a right in, you bring its whole jurisprudence, right? The whole.
That just now the courts pretty much designs the rights of citizens. Now the courts in a position to pick which rights are enforced,
Right.
which rights are not.
Right. So there's a huge body of criticism out there, right, about this idea of selective incorporation, right? Which is part of what Justice Black was saying, right? It starts with Justice Black's argument saying, well, this is, this makes it subjective. This lets the justices decide which rights are fundamental enough and which are not. Now, how do you decide, right? Now, the next question is, how do you decide what to incorporate? By the way, I put this in green, not just because it opens the door to more rights, but also because that's the majority, that's the law. Right? That's the state of the law today. Selective incorporation, one act. And the theory of selective incorporation is what the court eventually, through the Warren Court and beyond, adopted as the theory of how the Bill of Rights applies against the state. So the question then becomes, well, what do I incorporate? And you go back to these quotes, basically. You go back, the court just goes back to, well, what we will incorporate is rights that we consider fundamental. Rights that are, the fundamental principles of liberty and justice. Rights that are rooted in tradition and conscience. Rights that are required by, basic notions of decency and fairness. Now you just read McDonald v. City of Chicago. That is what Scalia and Stevens are arguing about. Okay? That is the best example you could have of that argument on both sides. Scalia says, okay, fine, I have bought into your due process incorporation theory because it's been around for 100 years. Well, not 100, 50 years. So I'll grant you that, right? I'm okay. This is green, right? I'm there. I'm not going to overrule the whole thing. Even though I think it's a bad idea, but I'm not going to overrule it. But when I'm making the choice of what to incorporate, I will try to find the most objective possible way of defining rights as fundamental. And because I am an originalist, right, my way of finding the truth is to look at the text of the Constitution and the original intent and meaning of the words. And so he looks at the history and he says, the right to bear arms has been rooted in tradition in the sense that it has always historically been protected and valued by our people. And it was the original intent of the framers to include it as a fundamental right. Therefore, it's incorporated. Stevens, on the other hand, has a much more complicated theory. What does Stevens, does anybody understand what Stevens is trying to do? No? Well, Stevens, so they engage in this debate in which Scalia accuses Stevens of saying, you're engaging in moral philosophy. Right? Yeah.
I thought Stevens was just saying since it didn't offend the disordered liberty, then it wasn't a fundamental right in the 14th Amendment.
Right, so he talks about this idea of ordered liberty, right? Again, he's using this terminology, right? It's almost like he's going back to this fundamental fairness approach and saying, I'm just going to look at all the circumstances, right? The totality of the circumstances. Yes, I will take into account history and tradition, but I will also take into account our current notions of morality, our current notions of conscience and decency and fairness. I will also take into account what other people do around the world. That's a highly controversial thing in the Supreme Court, right? To think of, can there be another system out there that we consider civilized and decent and fair and reasonable, you know, that protects the dignity of human beings, that doesn't have a right to bear arms? And he says, yes, of course. There's English-speaking countries, right? There's a quote somewhere. I think it was Frankfurter. Yeah, Frankfurter in Adamson. He talks about decency and fairness, and he talks about notions of justice of English-speaking peoples, particularly. I think that's really interesting, kind of ridiculous, but anyway. But Stevens says that, right? He says, you know, in Australia and in Canada and in Britain, right, our sort of sister countries, they have limitations to the right to bear arms, and we consider them civilized and reasonable people, you know. So it's not so fundamental to the system of ordered justice as, you know, a prohibition on torture against criminal defendants, which traditionally had been thought of as something basic, you know. Not so much recently, but you know. We don't think they're, you know, crazy, backwards, you know, countries because they don't have a right to bear arms, so it's not fundamental enough, and he would leave it out. Now, Scalia answers, well, that's your opinion, right? And that's the problem with your approach, that it only is based on your subjective, unelected justice opinion. Stevens retorts, well, your opinion of history is only your opinion. Right? My subjective appreciation of what you call moral philosophy is just as subjective as your subjective appreciation of history and tradition. And so they go off, you know, so that's the debate. Is Scalia's approach really more objective? Stevens says no. I tend to agree with Stevens. Is Stevens' approach very subjective? Scalia says yes. I tend to agree with Scalia. Right? I think both approaches are subjective. What do you do in that situation? I'm not sure. Questions? Now, what I like about Stevens' approach, even though it's a little confusing, is that, you know, at least he tries to say, I will take into account everything, right? It's not that I'm just basing myself on my notion of moral philosophy. I will take into account tradition and conscience and history also. And I sort of equate that to what Justice Marshall, we see Justice Marshall doing in some of those early opinions, right? Sort of approaching the question from every different mode of interpretation, and then seeing where the chips fall at the end, right? Are there more that weigh this side or on this side? Is it subjective? Yes, of course it's subjective, but at least you're not, you know, leaving some of the approaches out or picking and choosing your mode of interpretation. You're laying it out on the table. At least it's transparent. I'd rather have the subjectivity be transparent than it be hidden in your choice of dictionary, for example, which is what happens a lot of times with more originalist or textualist approaches. But that's just my opinion. Is it problematic? Hell yes, it's still problematic. Questions? Does that sort of answer your question about, I don't like this because judges will do what they want?
Yeah, it seems so subjective when I said that.
Yeah, I mean.
So it answered it, but it doesn't comfort me at all.
Right. I agree with you.
All right, moving on.
Yeah, sort of, well, we can think about alternatives, right? What alternatives are there?
Well, I mean, the total incorporation, it would seem that, you know, all these, if we include all rights, then through the course of like litigation, like those rights will be defined a bit more specifically, and we'll have like an actual thing, as opposed to just like a pick and choose method by whoever the justices are at that time. I mean, the way that the courts, like there's Lochner error, there's Warren error, like the courts are very different depending on who's there, and so we're going to get different results each time.
Right. So total incorporation would seem to solve a little bit of the problem. The problem then becomes, what is the right? Right? So if we're going to totally incorporate the Bill of Rights, well, what is included in the Bill of Rights? Right? Well, what's there? Right? What's textually there? Okay, obviously, right? So what about privacy? And I mean, we'll go into this later. What about privacy? Is the right to privacy included in the Bill of Rights? How many people say yes? Not textually, but as your gut feeling, right? Is privacy included in the Bill of Rights? Show of hands. Yes? No? Oh, come on. How about you just don't care? That's not cool, guys. That's not. By the way, I haven't posted the damn opinions from last semester's arguments. I haven't had the chance to do it. And obviously I didn't take the voting or not voting into account in your grade. I will post them at some point and have you guys vote. That aside. So, you know, most of us sort of feel that privacy is a part of the Bill of Rights. And we'll talk about that more when we read Griswold. There are these penumbras, right? And you sort of feel like, damn it, my free speech rights should, you know, in some way include the privacy of my thoughts, you know. They should include the Fourth Amendment search and seizure thing, includes the privacy of my home, right? Et cetera, et cetera. So I think even on the total incorporation, some of these questions would come. Right? Of, are there other rights? After all, you have the damn Ninth Amendment, right? You have that little problem to deal with. Because the Ninth Amendment gives you an instruction. You're supposed to include rights that are not here. And so the question of what are those Ninth Amendment rights would still grow up.
That would seem that we would be erring more on the side of inclusion as opposed to selection. I'd rather have that. I'd rather have more rights, and I can, shake a stick at than they were picking the rights.
That's a very good point. I think that's why Justice Black went for total incorporation, and that's why I personally like total incorporation. I agree. Just incorporate everything that's there, and then we can, argue about what else to incorporate, but what's there, at the very least, should be incorporated. Yes, right?
What exactly is the privilege and immunities clause for? It's not for this. Is it just like, it sounds pretty important, it's just like a buzzword or something?
Well, join Justice Harlan, right? I mean, and the funny thing, by the way, is I forgot to mention, Slaughterhouse was 8-1. The only guy that made the point that you're making was Justice Harlan. Justice Harlan has some pretty important things to talk about that later. But yeah, that's exactly the argument he makes. It's the first damn clause of the 14th Amendment of the Constitution. It's the most important amendment to the Constitution. It's what they did after a civil war. And you're telling me the first clause has no meaning? Well, that's what the court said. Now, you can see why a lot of people get really emotional about the slaughterhouse cases, myself included. Right? It seems like a really ridiculous opinion in that sense. I can't give you anything better than that. I think it's as preposterous as you think it. So, and that's what leads to this crazy incorporation via due process. And again, Justice Thomas agrees with us. Right? Imagine how preposterous the slaughterhouse cases are, that I agree with Justice Thomas on something. Right? He says, this is crazy. All this thing is crazy and it's unnecessary. You could have just done it through privileges and immunities. And it would, there's a discussion in the book about slaughterhouse. Somebody saying, the court says that we can't hold the privileges and immunities to incorporate the Bill of Rights because that would work a fundamental change in our system of government between the federal government and the state government. And somebody says, well, yes, it does. It's the 14th Amendment. It came after the Civil War. Of course it works a fundamental reworking. I mean, that's what it was about, right? Yeah.
I'm a little confused about why this was such a big deal, because Heller clearly stated 2 years ago the exact same law was valid. It was unconstitutional.
Heller was federal government issue. And what might be confusing you here is it was a District of Columbia.
Right, that was the difference.
And the DC is a federal creature.
Okay, that's
That's the difference. I mean, DC v. Heller establishes the substance of the right. Right? Says the right includes your personal right to self-defense. And then McDonald says, yes, and it is opposable against the state self-defense. All right, let me take a picture over here. I'm erasing this side. So, I post these. So let's see what's incorporated. Now I heard you guys like the bubbles.
Bubbles are good.
Bubbles are good. So I'm going to draw some bubbles. Yes, I love the word bubble.
Onomatopoeia?
Bubble. What?
Onomatopoeia, it sounds like it is.
Yeah, it does. Right? Sounds like it's popular. So selective incorporation. I'm going to work off of a working model here. Royd's amoebas. Wow. Okay. So let's call this the world of due process. And it's a very crazy world. It's full of strange and wonderful things, including procedural due process, which we will talk about later in the semester, right? You know, process actually includes procedure. Who would have known? And there's certain things, certain hoops that the government must go through when they're doing something badly. But in addition to that, as we have seen, it incorporates certain substantive rights. And so you have things like the right to a speedy and public trial. So all of these things that I'm putting in here are things that the court throughout the years after Black and Frankfurter had their debate has incorporated through the due process clause against the state. You've got the right to confront witnesses. You've got the Sixth Amendment right to counsel. Now, most of this was done in the Warren Court era. The Warren Court just went off and started incorporating all these things. What some people call the constitutionalization of criminal procedure. Like all of these things were constitutionalized so that every state had to guarantee these things. We've got unreasonable, this one should be bigger really. The right against unreasonable searches and seizures. I can give you the case citations, but I won't. This is Gideon v. Wainwright, one of those super important cases. This is Matt v. Ohio. You've got, I think I missed here. So these are, you know, Fourth Amendment, Sixth Amendment stuff for the most part. Of the world of the Fourth and Sixth Amendments over here. You can start adding over here Fifth Amendment. Privilege against self-incrimination. And again, this is the totality of the privilege. Right? Now, no, you don't have this splitting of it anymore. Now the whole privilege. You can't be compelled to testify, and the prosecutor can't, you know, hold it against you. They can't tell the jury about it. You have takings. These are both Fifth Amendment. You can't take property without just compensation. You've got cruel and unusual punishment. This is one that I feel quite strongly about. Pretty important. Eighth Amendment. You've got jury trial in criminal cases. This actually comes from Article 3. And you see, that's why I had the plus, right? It's the Bill of Rights and some other things that might be in the actual original text of the Constitution, as is the case with jury trial in criminal cases. Or it might be, you know, other stuff. We'll talk about privacy later, You've got freedom of the press. You've got free speech. You've got freedom of religion. Or what I shall call the religion clauses. These are all First Amendment. And you've got, most recently, the right to bear arms, which is the second. So we got first, second, fourth, fifth, sixth, eighth. What are we missing?
Well, yeah, a lot of other things.
If you want a summary of this, you can go to Duncan v. Louisiana, which is a case from the 60s, 1968. Right, 1968, right before the Summer of Love. You know, the height of the groovy movement. Now what's missing? Anybody recognize any stuff that is missing? Go down the list. We've got the First Amendment. We now have the Second Amendment, which we didn't have a few years ago. We have the Third Amendment, right? So we're missing, let me put this in red, just to make the point. What's the Third Amendment? Quartering of soldiers. Yoo-hoo! So much fun. Now, why do you think this hasn't been incorporated? There's been no quartering of soldiers going on, right? No quartering of soldiers since the 1930s, thank God. So it hasn't come up. Could it potentially be incorporated? Yeah, right? We don't know. The court has had no chance to deal with that one, thankfully. Fifth Amendment. Well, it's there, you're going to say, but there's a part of it that isn't there. Specifically, the right to grand jury indictment. The Fifth Amendment talks about the fact that when you are indicted of a felony, the indictment has to be issued by a grand jury. Now there are some states, for example California, you might remember from the O.J. Simpson trial, or you might not, has a preliminary hearing system. Actually Puerto Rico has a similar system. It doesn't go to a grand jury, it goes through a judge. The judge passes judgment on whether you can be indicted or not. That is constitutional because the court has said, you know what, having a grand jury indictment isn't so fundamental to this system of ordered justice, right? A preliminary hearing system is just as good. You still have a neutral decision maker. You're still going to have a jury of your peers eventually pass on the question of your innocence or guilt, right? So just indicting you, you don't need the grand jury. Sort of makes sense? Yeah. Not good enough, right? What's the big deal? Just include it, right? I mean, if the founders thought it was important, just put it in. I'm with you on that. So the 5th, the 6th is over here. The 7th. What does the 7th Amendment give us? Jury trial and civil cases. And this is another one that hits close to home with me. No jury trial in civil cases in Puerto Rico. Constitutional because it has not been incorporated, and that's actually been decided by the court also. The court faced this question, it said you don't have to have a jury trial in civil cases in the states. Again, not something that fundamental, it's just money, it's not throwing you in jail, so it's not such a big deal. That's what they said. And then finally, the 8th Amendment, to the extent that it prohibits excessive fines. So, the 8th Amendment talks about there shall be no cruel and unusual punishment nor excessive fines imposed on the people. The cruel and unusual part has been incorporated, the excessive fines part is not incorporated. Again, it's just money.
Can you go back to the incorporation of the cruel and unusual part then?
What do you want to know about that?
Where did it go?
What do you mean? It's here.
No, but I mean, they still seem to not abide by it.
Oh, you well, that's an issue of substance. It's just right. I mean, there's a really good case. I don't know if you guys have read it. Hammerlin v. Michigan. It's a case from the 80s. Scalia writes the opinion, and basically his argument is, well, the punishment is cruel, but it's not unusual. That's the argument. It's a guy gets life in prison for cocaine, and the exercise. I got this exercise in my legal writing class, my first exercise, and I used to do this to my students when I taught legal writing. First exercise, you know, you're just coming into law school, you have no idea what you're doing. They give you this case, you read it. It's terrible. I mean, this guy just got convicted of having cocaine and has to live the rest of his life in jail. It's pretty, you know, heavy. And he goes all the way to the Supreme Court. Supreme Court takes the case, and Scalia tells him, yeah, I know it's cruel. But, you know, we tend to be cruel. It's not really unusual, so screw you. And the assignment was, now you have to be the attorney who writes the letter to your client informing him.
Dear Mr. Sorry.
People have fun with that. And what can you do? Right?
Get to it.
And again,
came out
it's one of those things where I like to make people think about what happens when the court fails you, right? What do you do? Well, you have things, right? You can ask for executive clemency. You can ask the legislature to see your case, change the law. You can do certain things. You're kind of screwed, but you can try. Right? So, yeah, I agree. But that's an issue of the substance of the right, not the incorporation. So next time, I will talk briefly about the state action doctrine. You will see that, you know, I assigned you 20-some pages, and then there's an optional assignment. I'm not going to discuss the optional part. It's basically the exceptions to the doctrine. I'll mention them, but I'm not going to discuss them. For the bar, again, recommend you read it at some point in your career. You don't have to for tomorrow.